Hi, folks. Denise, Howell here, and that non-intrusive buzzing you hear is the TWiL panel firing up their drones for launch. Join us to discuss phones, drones, and privacy for royals, candidates, and you and me. We're going to do crowdfunding and the Jobs Act, what's hopping with AutoHop, trademarking a color, and lots more with Chris Sloan and Will Norton, Evan Brown, all next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise, Howell, and Evan Brown. Episode 180, recorded September 21st, 2012. Boston-style Bluegrass. Enhance your workflow. Send files of almost any size easily and securely with Sharefile by Citrix. Try Sharefile today. For a free 30-day trial, go to sharefile.com, click the radio microphone, and enter the promo code TWiL. Hi, folks. I'm Denise Howell, and you have tuned in for This Week in Law, where we talk about everything that's fascinating in the world of technology and law. We've got some great guests to talk about all those things today. Joining us from the law firm of Baker, Donaldson, Behrman, Caldwell, and Berkowitz in Nashville, Tennessee, we have Will Norton. Hello, Will.
Hello, Denise. Thank you.
It's great to see you, Will. Wonderful to have you join us. Will and his colleague also joining us from the same firm, Chris Sloan. Hello, Chris.
Hi, Denise. It's good to be here.
Great to have you guys both. They are focusing on emerging companies and all the both legal and corporate formation and funding issues that those kinds of companies can face. So we're going to have some great stories about those kinds of issues on the show a bit later on. And can we stipulate, guys, that we're just going to call your firm Baker Donaldson? Because it's kind of a mouthful.
That's fine with us. In fact, that's the way most people refer to it.
Yeah, it's just 5 names. It's just excessive. It's too many.
Yeah. So now that we've got that out of the way, let's also welcome back to the show my co-host, Evan Brown. Hello, Evan.
Good to see you, Denise. Thanks for having me back. Looking forward to our conversation, as always.
Me too. Well, we've got lots of interesting stuff on the rundown for today. But let's start out with some stuff about privacy. All right. Interesting kind of convergence of events in the last week or two that got me thinking about issues concerning phones, drones, cameras, royals, and candidates. Because we have a few different stories that have involved different images and video that folks did not expect to be out in the public eye necessarily that are, thanks to technology. So I want to talk about the legal ramifications of all of that. Of course, I'm alluding to Kate Middleton and the photos taken of her and the Duke, her husband, on vacation, where I believe they were at some lovely chateau somewhere in France, and cavorting around in not too many clothes. And the topless photos of Kate were the result and are being published in some tabloid magazines, I believe, in Ireland, France, and Italy, if I've gotten all that coverage right. Coverage is sort of a funny word to use in this context.
You said it.
So these photos obviously were captured. The photographer or the news outlets, if we can loosely agree to call them news outlets, have said they were taken from a public place, and so they're fine. But of course, the royal family doesn't think so, and has decided to sue. So they're going to be trying to stop the publication of this. They're going to be relying on the much more stringent European privacy laws than we have here in the U.S. But more interesting than the fact that this has happened now, to me, is what's going to happen in the future. I have my son's little AR drone here with me in my home studio today because he loves flying this thing. It's mostly about just kind of buzzing around the park. but it has wonderful cameras on it. And you get pretty good imagery out of these things. In fact, when you go to the AR Drone website, they have a whole section about possible commercial uses of this little children's toy, where in the past news organizations have used these AR drones to fly into. I think there was a damaged church they're promoting on their website. The drone went in to survey the damage, and also some storm damage somewhere where you don't want your reporters getting in harm's way. They take really wonderful footage, and they're not very loud. I mean, I think if one of these flew into your backyard, you'd think twice about running around without your top on. But they're getting smaller and smaller. You guys have probably seen going around this tiny little mosquito-sized camera thing that Snopes says is not actually a thing that is out there, but is reminiscent of something that the government is working on. The Snopes sort of doesn't completely debunk it. It says, yeah, there are small drone camera prototypes out there.
I guess it's kind of a thing then, or something like that.
Yeah,
sort of exists, and maybe not exactly like that.
Right. Well, they don't completely shoot it down, this little drone, this little mosquito drone.
They just swat at it.
Right, exactly. So I think we're getting into a really interesting time where, you're not just thinking of photographers with their telephoto lenses chasing after celebrities, but there are, government applications of this. Of course, lots of law enforcement agencies are trying to put drone technology to work for them. So I wanted this to be our first topic for the day, and just see what you guys think about all this, and where we're heading on the legal front as far as being able to protect people's privacy in the face of these developing technologies. Evan, what do you think?
Well, I think probably the really important issue for us, or at least the starting point for evaluating this issue, is looking at what kind of remedies we would be pursuing in the event of somebody misusing this technology. When we're talking about Kate Middleton and the photos that were taken of her, I mean, that of course wasn't a drone, but it was somebody standing on a public road with a telephoto lens peering into private property. We just jump, make a very short jump over to by analogy, thinking about how these types of things could happen more often with the use of drones. Flying over property, you wouldn't have to, be too invasive, but you're flying over to get these kinds of photos here. So, I guess the first thing I think about this is really the futility of pursuing any kind of remedy once the damage has been done. I mean, we're looking at, France, for example, earlier this week entered an injunction against that French publication from disseminating the photos any further. And I know that also one of the terms of that injunction, or one of the things that the publication had to do, was turn over the photos. Now, good grief, is that not the silliest thing you've heard of as far as a remedy goes in this day and age, when there are innumerable copies of these photos that are out there because of the distributed nature of the web, and it's not hard to find copies of these images using Google Images or whatever image search engine of your choice. So what we have to do in looking at how to handle this problem is evaluate the liability and the penalties that attach from actually using the technology in the first place. And to make it more specific, I think that really we have to drill down and look at meaningful regulations on the uses of technology at the very beginning, at the very fundamental level, being very detailed about who it is that can operate a drone and what kind of information they can collect, taking care of the regulatory part of it so as to not have to worry about the punitive part of it in the event that there is a disclosure. We got to minimize the risk that there's going to be a disclosure of sensitive information, whether that be topless photos of someone or information that's gathered from continued surveillance. So my thinking is that we have to focus on the use of the technology as it's actually being used, rather than worrying about getting the genie back in the bottle after there has been a leak of sensitive information.
Yeah, I agree with you. I'm concerned too that whatever kind of, whether it's legislation or industry guidelines go into effect, they're going to be aimed at more the law enforcement or commercial uses of these things. But meanwhile, everyone who has a technologically inclined child might have one of these in their own home, and the uses to which they could be put without being swept under that kind of legislation, I think is kind of concerning. Will, do you think that it's sufficient for industry members that are going to use this kind of technology to agree to guidelines and things, or do you think we need more?
I think it's really difficult to do it industry-wide, and I think one of the reasons, and this is something that Evan, I think, was alluding to a certain degree, is once the genie's out of the bag, it's really tough to bring it back. And I think there are different sort of cultural norms that we see in different countries and with different, sorts of publications. Tabloids definitely are not going to agree to the same sorts of guidelines that the New York Times is. And so it's going to be difficult to do it and I think this is the biggest problem with privacy in general, is trying to do something that will kind of cross all bounds of industries and countries and all of the different kind of cultural norms and expectations. Privacy a lot of times is tied to what is the reasonable expectation of the person whose privacy we're trying to protect. And as, for example, drones are flying overhead, does our expectation to privacy change? And does that change how the law will choose to protect us based on, if I see drones flying overhead, I'm not going to go outside thinking that I won't be seen. Does that change the privacy protections that I should receive as an individual? I think there are a lot of issues kind of tied into this, but one of the biggest is once it's out there, there's no coming back.
I think one of the interesting things that we're seeing here with privacy is, and this all this new technology that's being developed, you're starting to see some of the same challenges for the legal framework that we saw when the internet first came online, and all the challenges that people faced with intellectual property laws trying to cope with this new internet-related framework. I think you're seeing the same thing start to develop in the privacy framework. There's all this technology that never existed when many aspects of the current framework were developed, and it's going to be really interesting to see how it evolves. And I think, as Will mentioned, one of the challenges is the different cultural norms about privacy. The U.S., particularly in internet-related privacy, and I'm expecting to see it function similarly in the more expanded technology realm, really has done very little in terms of regulating privacy, whereas many other countries in the world take a much stricter approach.
Well, we've got a congressman who is trying to change that. Representative Markey has a draft pending called the Drone Privacy and Transparency Act, I believe it is. This is Edward J. Markey from Massachusetts. Interesting stats here in his press release about this. The FAA estimates that by 2020 there could be 30,000 drones in use over American skies, designed to carry surveillance equipment, including cameras, thermal imagers, radar, and wireless network sniffers, with the capability of collecting sensitive information from the skies above. So there is legislation that has been proposed on this. So, hopefully Congress is paying attention. And as the technology continues to develop, so will our norms and rules about what's okay and what's not. Getting back to the Kate Middleton story for a second, I want you to tell me if I'm just out in left field here, but I started to think about the right of publicity, which is one of the things that the royal family would be asserting here, use of Kate's likeness without her permission for commercial purposes, and however that may be protected in the European countries at issue here. Certainly in the U.S., various states have protections for that. But when you start thinking about it in practical terms, let's say I'm thinking about it in terms of sites that host images and allow users to post images like Flickr or Instagram, Google+, Facebook, you name it. So many of them out there these days. So suppose you have taken an image of someone. Doesn't have to be a celebrity. The right of publicity usually applies to everyday individuals as well as celebrities. And you've posted it up. When you do so on a site such as those I mentioned, you're generally not doing it for commercial purposes. You're doing it because you've taken a photo and the person either happens to be in the photo or you were specifically taking it of them. But you're not generating any revenue from that. You're using probably a free service to you, and one that the people following you and viewing whatever it is you're posting are not paying for either. But the site itself is making money, right, from the advertising or the fees they charge or what have you. So I've never seen the case yet where a right of publicity claim has been asserted against the site itself who did not post the photo or video. And in most circumstances, maybe we need to have Professor Goldman on the show to answer this one, Evan. I think Section 230 would ride to those kinds of sites' rescue, but it really seems to me a conflict between the two principles because the right of publicity laws definitely want you to have to take things down if you are commercially benefiting from something without someone's permission. What do you think about that, Evan?
Well, yeah, I see what you're saying, and I think that we could easily turn it into a Section 230 analysis. And I'd have to do some research on this. I would have looked into it before the show if I'd known we were going to go this direction. But I think there's been a case involving Amazon from a few years ago where somebody sued Amazon. I believe that there was a Section 230 issue raised with all of that. But I would submit that we don't even necessarily need to get to the Section 230 argument because, Section 230 is asserted as a defense, depending on what court you're in, it's an affirmative defense, or it could be just something that you could use in like a motion to dismiss, saying that the other side hasn't pleaded their prima facie case for all of this. And in any event, setting all of that aside of using Section 230 as a sword, you could just defend yourself, I think, from a right of publicity claim if you were an intermediary like Flickr, just by saying that there really isn't enough of a nexus between the use of the image that's being made and the commerciality of it. Flickr is not, somebody posts a photo of Kate Middleton onto Flickr. It's not like Flickr is using that photo to promote Flickr's services. Flickr is just showing the photo. And yes, it may be making money from it, and there may be ad revenue or whatever, but I don't know that that's what is countenanced under most state statutes. Of course, we're talking about U.S. law here, but what's countenanced under most state statutes and the common law of the various states who talk about the right of publicity for using it for commercial purposes. So going back now to talking about Section 230, I think where there may be some uncertainty as to whether Section 230 would provide a defense here, because there is an exception to immunity under Section 230 that says you as the provider of the interactive computer service can't rely on it to protect you from a lawsuit alleging the misappropriation or infringement of intellectual property. Now, there's some case law, I know from the Ninth Circuit, that says that only pertains to causes of action that arise under federal law for intellectual property, but it's by no means a settled issue nationwide. So at best, it's an open question as to whether Section 230 would provide immunity to a provider here for a claim that is asserting the misappropriation of one's right of publicity. Clearly, it's a fun issue to talk about because there's different ways of looking at it, and it presents more questions than it does answers.
It does. Chris, do you want to try and answer any of those questions?
Well, I think there's another interesting analogy here in terms of the way you could address the concern. And you talked about intellectual property, and we have a mechanism, a safe harbor in the Digital Millennium Copyright Act for dealing with these same types of sites that are really just a medium for this content to deal with copyright infringement. If you post something that's an infringing picture on one of these sites, they all, for the most part, have a notice and takedown policy where the rightful owner of the copyright can comply with a very simple procedure and have the site take the content down. And I wonder if there's not an opportunity to maybe have a similar construct under Section 230 since it seems like the issues are analogous.
Yeah, that's an interesting thought. Let's move on to a related story. Someone else who had some imagery, this time audio and video imagery out there that they didn't necessarily expect to get such wide exposure, and that is presidential candidate Mitt Romney with his remarks in Boca Raton, Florida back in May, who somebody, I think, just took a video of with probably their phone camera, got into the hands of Mother Jones, and now we're all talking about it this week. His famous 47% remarks and the flack that Mr. Romney's taking for that right now. Whatever your politics are, whether you agree with the remarks or are somewhat inflamed by them, the fact that they're out there, I think, is pretty interesting, and the fact that maybe candidates aren't thinking about this at their private fundraising dinners in people's homes, which happen all the time during the campaign season. Everyone in those rooms has a phone, and if they want to, they can record what's going on there. So, it's just another one of those places where candidates have to be mindful of what they're saying and mindful of the fact that there can be public discussion about what goes on behind those fairly closed doors, unless you've written a big check to get in. So one really interesting thing I thought about this story is, the source of this video is still anonymous. Mother Jones has not disclosed who took the video. There's some interesting coverage at the Washington Post about how the video came to light and how they persuaded the person to release the whole thing. But one little tidbit in there that I found fascinating is that Florida laws prohibit the recording of anyone without their consent. And I'm wondering how Facebook does business, or anyone who uses Facebook uses that product, or, things like it, in the state of Florida, where, people are constantly taking videos and putting them up online. Facebook just capitulated in Europe to privacy pressures there that made it remove the auto tagging feature for facial recognition. So this seems like an interesting twist in Florida, too, where maybe this law just isn't being enforced. Evan, what do you think about the whole Romney public video scenario?
Well, I agree with you. I think the interesting issue is looking at it under Florida law to see if there was anything that, was run afoul of by the creation of the video in the first instance. Mm-hmm. And yeah, you're right. Florida does have a statute that is that prohibits eavesdropping and recording conversations. Like they call it a two-party consent state. You got both parties have to know that they're being recorded. But there's an exception to this that I think makes the statute not nearly as restrictive as one might think. On first reading, it's kind of where the exception almost undoes the rule in this situation. And there's the exception is for any in-person communication that is recorded when one of the parties doesn't have a reasonable expectation of privacy in the communication. So if you're on a public street talking to someone and you're talking loud enough where passersby might be able to hear you, you would not have a cause of action, or you wouldn't be criminally liable under this statute. And, I'm not licensed in Florida. I don't know the nuances of this, but I did look real quickly, and I did find a case from Florida from 2004 called Coen Brothers. I don't know if it's like, the awesome filmmaker Coen Brothers, but the case is called Coen Brothers. And in that situation, the issue is whether or not a conference call among members of an LLC's management committee was a violation of this statute, and the court found that it was not a violation because the members, there were several people on that call, and the court found that there was no subjective expectation of privacy when there are several people on the call. So I think it's pretty easy to analogize that situation to the Romney situation. With it was a large group of people. Ostensibly, it was a private event, just like a conference call is a private event. Unless you're the FBI talking about how to handle anonymous. anonymous. Never mind. And so that was, just a situation where, even though the members of there thought that this was not an event that was open to the world, just like a Mitt Romney fundraiser is, there was no expectation of privacy here. So for that reason, I think that this exception would probably do away with any form of liability that Romney could assert, for taping this. It sounds like it was something that's probably permissible under this. There's still several other issues we can talk about. The protection of the press, all the anonymity and all that stuff. So, but like you, I like this issue of the eavesdropping and whether or not it was a violation of that.
Yeah, we have a similar law in California. I don't know if it has that kind of exception or not. Chris, do you think that candidates need to be rethinking their fundraising dinners and the things they say there?
I do think they should think about that, because I think once you become a public candidate, that ship's already sailed. When you're in that context, you're even in a dinner with people who are contributing to your campaign. I think you should be concerned that anything you say might be repeated, and I think that's the way it should be. I think that should be part of the process. Interesting to note that Tennessee is actually a one-party consent state, so in Tennessee there wouldn't have been a legal issue with that recording, but I agree with Evan that I think that there shouldn't be an expectation of privacy in that context generally, and certainly not for somebody who's a candidate for public office.
You don't mess around in Tennessee.
That's right.
No. It's sort of the anti-Florida in that sense. What were you going to say, Will?
There's a strong First Amendment issue here, right? I mean, this is a public, something that the public needs to be aware of to be able to, as a democracy, we need to have information about our candidates. They have less of a sense of privacy themselves once they become public figures. And I think this was an important issue that the privacy kind of issues you might be thinking about normally are going to have to be weighed against what's the public good for letting this information be available. And I think in this sort of a case, probably the First Amendment kind of the First Amendment qualities that we're wanting to support as a democracy are going to win out. And I also think one interesting issue is, what if they would have had any of the attendees sign something when they came in and said, I won't tape record this, I won't take any video or audio? Would that be any more or less likely to stand up based on the privacy or First Amendment issues?
What kind of damages? I mean, at best, you'd have a breach of contract action, but what kind of damages are you going to have? Romney loses the election. Was he going to sue for the salary he would have made being president?
He'd never sue. I mean, this is just kind of pie in the sky talk. There's no way that even a candidate with a right to sue in a situation like this would do it, because, the PR ramifications would just be so bad.
And I think that's the funny thing is how you would never expect that your own sort of supporters would be releasing this video. So I think that's the sort of issue. They probably just never even thought it would come up.
Right. Well, I have no idea or no speculation about who this person was, but would just observe that people work at these kinds of dinners and that people get brought to them who may not be the supporter. If you're the spouse of someone who is going along, you may not be of the same political persuasion as your significant other. And as you're sitting there listening in outrage, it may be just too tempting not to turn on your phone and capture what's going on.
I think one neat aspect of all this is that it was Jimmy Carter's grandson who was the researcher who first brought this to Mother Jones's and HuffPo's attention. So it's interesting to see what interests were motivating some of the players in all this. It was much more than just to undercut Mitt Romney's campaign. It was also to vindicate Grandpa in this. So it really neat to see how interests can underlie motives and really motivate people in unusual ways.
Yes, indeed. All right. Well, one thing we know that you want to stay private in all circumstances are your business communications. Because in business, we're constantly collaborating with colleagues and clients, sharing files like contracts, spreadsheets, presentations, and it's essential that those important files are kept safe, secure, and under your control. So what are you going to do about all this? Here's what you're going to do. You're going to use Sharefile by Citrix. It's the easy-to-use business solution that allows you to exchange files quickly and securely. Now, it's also just wonderful for our mobile lifestyles today. I've been a couple of days this week down a little bit south of where I live, having a little staycation with the family, and very cut off from my ordinary work system, just, traveling around basically with an iPad. And still needing to keep tabs on what's going on. And Sharefile is great in that situation. They've got a mobile app that lets you use their services wherever you are, whether you're working on documents or great big files that you just simply cannot send over email. You can always share them with Sharefile and know that they'll get to the person they're supposed to go to, only that person, and exactly the right access controls for anyone that you would like to be able to share the file. You can send files of almost any size with no email bounce backs, because that's how this works, right? It's not actually going as an attachment to your email. You can control who has access to your files. All the levels of permission that you need are very easy to set. It syncs automatically, so you and your team will always have the most updated materials, and you can access Sharefile from anywhere. As I was saying, your iPad, your other tablet, your smartphone, your laptop. So here's what I want you to do. I want you to try Sharefile with this special offer. Sign up today. You'll get a 30-day free trial. To do it, go to sharefile.com, click on the radio microphone, and enter the promo code TWiL. Remember, visit sharefile.com and type in the promo code TWiL. All right, let's move on and talk about a piece of legislation enacted earlier this year and some legislation and policy concerns. So we're really fortunate today to have not just one, but two experts in the field of the Jobs Act and emerging companies and how they might take advantage of the new provisions of the Jobs Act, and how the Jobs Act might also, in turn, affect investors and what they're able to do. So we're going to talk about a few different facets of that. Let's talk first about crowdfunding, because that seems to be what just about everyone is interested in about the Jobs Act. Chris, can you give us an overview real quick we've covered it on the show before, but just in case there are people who aren't familiar with what this is and what's coming down the pipe?
Sure. What the Jobs Act enables, in short, is, well, it really does a number of different things, but it does two things that are going to be of interest to startup companies. On the one hand, it creates within the general framework of Regulation D, which is the safe harbor that most startup companies use to raise funding. It's typically for private placement transactions only. One of the aspects of the Jobs Act is it allows for general solicitations for investors under Regulation D. So you're now permitted to advertise, essentially, on Reg D offerings as long as you take steps to ensure that you're still dealing with accredited investors. And that was actually the first set of proposed regulations that came out under the Jobs Act a few weeks back. The other piece of it is the ability to there's actually a new exemption that was created under the Securities Act for raising money from unaccredited investors via either a broker or a crowdfunding portal. So previously, if you were trying to raise money from unaccredited investors, and for individuals, the simple way to think about accredited investor, if you're not familiar with the term, is it's really sort of a proxy for people who are relatively wealthy.
People who might be at a Romney fundraising dinner.
Exactly, that's
now,
right.
Denise.
So that's a simple way to think about it. It's more complicated than that, but that's a simple way to think about it. If you were trying to raise money from unaccredited investors, the exemptions were more difficult, and the process typically would be more expensive to go through. So there's now a new exemption that allows you to raise money from unaccredited investors through a new exemption to the Securities Act, provided that there are limitations on the amount of money that you can raise within a 12-month period and the amount of money that any particular investor can invest, and it's related to their income or net worth. So it allows you to have access to pools of investors in both contexts that you might not have otherwise.
Okay, so we've got the SEC slowly enacting the rules that are going to make this useful for people. We have, who is this here? Representative Scott Garrett from New Jersey, not very happy with the speed with which the SEC is taking action here. But slowly but surely, I'm sure the SEC will do what it needs to do to make the Jobs Act functional. Can you explain for us, Will? I understand the difference between using something like Indiegogo and Kickstarter and doing an offering under the Jobs Act. In one instance, you get maybe a widget or a sticker, depending on your investment level, some concrete kind of recognition from the company that you're funding. And in the other instance, you get equity. So how's that going to work? Because if what you're getting is equity in a small company, and we're talking about unaccredited investors potentially now being able to partake of this, how's it going to play out in the long term? Will, are you there? I think he's frozen. Chris?
Frozen. That's pretty awesome response.
Chris, can you take this one?
I'm going to answer like that next time.
Yeah.
I think the mechanics of it and how it's going to play out. It's still to be determined. But I think the upshot of it is that it's going to allow more companies to get off the ground than otherwise might have, because they'll have access to broader sources of capital. And I think at the end of the day, that's going to be a great positive for all of us, for the startup community and the economy generally, because there's all sorts of statistics out there that talk about this, but entrepreneurs are the ones who really create the majority of jobs in this country. It's not the Fortune 100 companies. So anything we can do to kickstart, if you'll pardon the pun, entrepreneurship is going to be a good thing. I do think there's some concerns about how crowdfunding is going to work, particularly for companies that are going to go through multiple rounds of funding. There's some concern, I shouldn't say concern. There's been some speculation that later institutional investors like venture capitalists might have some concerns about investing behind a large number of small unaccredited investors, and whether it might create some more risk in terms of director fiduciary duty type claims from unaccredited investors. But those concerns will sort themselves out in the market in the long term. I think on the whole, anything that's going to allow more companies to get founded and launched and start creating jobs is going to be a good thing for all of us.
So let's say one of the articles we have in our discussion points today was from Forbes, and is a very practical look at the Jobs Act, 4 ways your business can benefit from crowdfunding. And it talks about the reasons why this is good, the reasons why this is good for entrepreneurs. One of the things that's talked about here is you're not going to have to sit around at Thanksgiving dinner and hit up your father-in-law for a $10,000 check. So let's say you're instead of doing that, you're getting lots of little investors to make up that $10,000. How are those folks going to realize anything from their investment down the road? I mean, we're talking about small private companies. Are their shares going to be marketable? How are they ever going to cash out?
Well, that's going to be one of the interesting questions in terms of how the market works for these companies. The traditional company that might be investable by a venture capitalist or an angel investor is one that there's an expectation that, in 5 to 10 years, typically around 7 years, there's going to be an exit event where they're either going to go public or they're going to be acquired by another company. And at that point, there'll be a big liquidity event for all the shareholders, including the investors. So one of the interesting dynamics about this crowdfunding concept is going to be how a larger mass of people does at picking companies, and whether some companies that may go on a different track, will get funded. There could be companies that are really going to grow and be steady revenue generators that may, instead of aiming for a big exit event, distribute cash to their shareholders via dividends. And that might be another way that some of these investors are going to get their money back. But it's going to be interesting to see how crowdfunding works.
Okay. I think we may have just had there we go.
Am I still there?
You are. You had a little Skype glitch there.
Sorry. I think it's been interesting in the past whenever we've had events where the general public were voting on startups at pitch contests and that sort of thing. The public voters have actually generally done a pretty poor job at predicting which of those companies were going to be most successful. So it'll be interesting to see how they do when they're voting with their money.
Right. Now, Will, you wanted to talk about taking the Jobs Act and how it's going to apply or affect corporate formation, and the fact that B corporations or public benefit corporations might really be able to use this in a positive way. Can you describe that for us?
The corporation is a corporation where, in addition to, in a normal corporation, the fiduciary duty of directors and officers is towards the shareholders and the shareholders only. You need to, there are cases coming out of Delaware that say you need to maximize that shareholder value at all costs. There's, a company that's going to buy you out or going to invest in a company that you don't necessarily like the culture or the way they want to run your business, but they're going to get you, they're going to improve your bottom line. Then that's the company you need to go with. That's the company you need to pick. Mm-hmm. These benefit corporations are trying to take into account more than that, and that's kind of a general public benefit. They're going to maximize their shareholder value, but their shareholders are sort of extended to not only the people who own stock in the company, but also the community and the environment, and just looking at sort of these general issues that corporations affect. And so I think public benefit corporations are probably going to have a lot more kind of sympathy from the public, saying, we as a community can try to support them, but I don't necessarily have the money that a venture capital does or a large investor does. I give a little bit because I think they're doing good work. And maybe I don't care as much about the bottom line. Maybe I think it's just as important to me that I make a little bit of money, hopefully, more than anything, that we're doing something positive in the community. So these benefit corporations have a little bit broader scope, and the idea is they're trying to take into account some of the issues that normal corporations are not allowed by law to be thinking about. They ultimately have to maximize shareholder value, and these benefit corporations, which I think are in about 15 or so states right now, they can look at kind of the broader spectrum of how corporations are affecting the public and try to do the best good for everyone.
So you just think that the Jobs Act is going to be a good fit for these kinds of corporations?
Yeah, so I think the crowdfunding in particular, the fact that it's really nice to be able to go onto Kiva and essentially help out somebody in another country that I wouldn't normally be able to help out, or to go onto Kickstarter and to help an artistic project. But ultimately, there's no ability for you in those scenarios to actually reap any financial benefits yourself. So this kind of, especially the crowdfunding applications of the Jobs Act, are going to create an outlet where people can give money and say, I have an expectation to get this money back and hopefully to make something off it, but also kind of do some public good. I think a lot of the crowdfunding, looking at what we've been doing on the internet to this point with Kickstarter and Indiegogo and other services like that, and saying, maybe we can do this and still let people reap a financial benefit as well, which I think hopefully can really propel some of these companies that are already doing some of the crowdfunding things to kind of go to the next level if they want to.
I think we're seeing a real trend in increases in social enterprises, particularly in the startup space, and I think this is just another component of it. The B corporation structure and the ability to leverage crowdfunding is going to fit really nicely into that growing trend of socially responsible startups.
Do you guys see this being mutually exclusive with sites like Kiva and Kickstarter and other things that don't rely on the Jobs Act, or do you see them happening for the same company in parallel? What do you think, Chris?
I think that's really going to be up to their individual business models. I mean, there's been a lot of speculation, for example, about whether Kickstarter would attempt to take advantage of the Jobs Act. Because as you talked about earlier, there's a fundamental difference between saying that if you contribute X dollars to our Kickstarter campaign, then you get a special widget at the end of the campaign, as opposed to getting stock in a company. So I don't think they're mutually exclusive. I think they're absolutely compatible. Whether you're going to see them handled together is really going to be a function of what the business models, how they evolve.
Evan, Steve Case, the founder of AOL, had some interesting comments. I think, where was he speaking?
Detroit.
Was he speaking in Detroit? Yeah, it was written up at TechCrunch.
So.
And he was talking about how, he was at the Techonomy conference in Detroit. And he was talking about how this new funding model may be a much bigger deal in areas that are not already well served by a thriving venture capital community such as Silicon Valley. Do you agree with that?
Well, I mean, I would leave it to Steve Case and other people who, have more insight into that and have spent more time thinking about it. So I certainly have no reason to dispute what he's saying. It makes sense, because I think more than saying that it would be good for Detroit, he was just saying it would be better for a situation where there's not as much capital. For example, Detroit versus Silicon Valley, where apparently there's more money just floating around waiting to be invested than people know what to do with. That's just the impression I got from that article. I don't have any other insight into that. If there is more money than people know what to do with out there, please somebody confirm that to me. I guess it goes to the more fundamental question of the benefit of democratizing this capital process by which investments can be made. And so I'll leave it to the experts to talk about what the real effects are and how it's actually going to play out. I mean, the interesting aspect that I see of it is how this could affect the companies who are the subject of crowdfunding and this democratization of the capital process, how that could affect their choice of legal counsel and all these things. If we're going to take it away from a VC-funded model and make it more toward everybody, where everybody is participating, even smaller entities who are making the decisions about what law firms to hire, it seems like that's going to open up a lot more opportunities for other lawyers other than just the big law firms that venture capital firms choose. I mean, this seems like there's a small subset of big law firms. You just got to look at like the law firms who filed the Facebook IPO documents and other big firms like that. So this one thing that I'd like to see is for the benefit of everyone, the lawyers who are involved and also the people who are going to receive legal counsel from more energized mid-market small law firms because of all this. It's a real benefit for the legal profession serving these clients and also the people who are receiving the services of a greater spectrum of law firms as well. So I think it would have to benefit places that are undercapitalized, so to speak, in more ways than just economic terms.
Yeah, I think that Evan's really hitting on a great point, that it's an entrepreneurial ecosystem, and that involves more than just the companies and the investors. It involves other entrepreneurs that maybe aren't starting companies but are there to mentor those companies that are there. It happens with lawyers that have experience with startup and emerging companies, accountants that have experience with startups and emerging companies. And when you have all of those pieces in place, that's when we can start to have these hubs all over the country. Silicon Valley is great, but Silicon Valley can't support the technology for the rest of the country. If you read Brad Feld's blog, I think he's been doing a lot of research and trying to look at what does it take to build an entrepreneurial ecosystem? And what he looked at is there are all these different inputs. And I think what the Jobs Act is focusing on particularly is on, obviously investment for these companies. But hopefully, as Evan mentioned, it'll open up opportunity kind of these businesses, accountants, lawyers outside of the mainstream to kind of come in and really support these hubs all over the country.
We definitely... Go ahead, Chris.
Oh, sorry. I think what you'll see is that the law firms will, it's the old sort of saying about, I think it was John Dillinger when he was asked why he robbed banks. He said that's where the money is. And law firms are the same way. They'll adapt to what their particular markets are telling them about where their best opportunities are to attract new clients. And so I definitely think that Steve Case is right that one of the great benefits of the Jobs Act will be providing more capital for launching more companies in mid to smaller markets that don't have a lot of focus from professional investors. And I think the trickle down from that will be more law firms that become interested in working with startups and early stage companies and technology ventures, and they'll start developing that expertise. I mean, we see it even just around our footprint. You know, we're all over the Southeast, and even in our markets, in markets like New Orleans and Memphis and Nashville, you know, there really aren't very many lawyers that have that experience, and that's where we saw an opportunity, and it's why we've grown our emerging companies practice the way we have. But the same thing's going to happen all across the U.S., hopefully, as a result of the Jobs Act.
And not to get too all flighty and laudatory about things, but there seems to be a great untapped potential and ingenuity and skill and talent in this country. It's so concentrated in Silicon Valley, and to the extent places on the East Coast as well. But I mean, of course, Chicago is a wonderful place where there's a very robust emerging technology ecosystem. Nashville is the same way. Bloomington, Indiana, so much cool stuff happening there. So, Boulder, Colorado, where Brad Feld is. So, with this kind of expansion and, tweaking the system so that it can be done more effectively, I mean, that's just got to be to the mutual benefit of everyone, not to the detriment of Silicon Valley. That's always going to be pretty awesome there. But, there's awesome places. There's awesome all across this country.
It's all about awesome everywhere. And even though the economy has not been so awesome, it seems like that is good for interesting startup companies, because when people get kicked out of or otherwise are not able to be in their secure, consistently earning job, that's when they start coming up with creative things to do on their own. And it seems like the Jobs Act is only going to help that. We'll go ahead and make crowdfunding our first MCLE passphrase for the show. If you're a lawyer interested in getting continuing legal education credit for listening and watching TWiL, head on over to our show wiki. And there's all kinds of details there about how you can apply for credit in your jurisdiction. We have lots of good resources on crowdfunding. There's more and more stuff out there every day. You can look at what we've been looking at to prep for the show at delicious.com/thisweekinlaw/180. One of the articles is by Dr. Jeffrey Cornwell, writing for the Christian Science Monitor. Seems like Dr. Cornwell, I haven't read something by him before. He seems to be a professor of some kind. He's talking about what he's going to talk about in his class here. But he pulled out a couple of companies I thought were pretty interesting. One is called In Crowd Capital, and it's in your guys' neck of the woods, Will and Chris. Are you familiar with Phil Schmerling and his company? It seems like he's trying to form a company around crowdsourced investing here.
Very familiar with it. In fact, they're actually a client of ours, and
great.
I just saw Phil a couple of hours ago. It's that he's building a crowdfunding portal, and he's got a very interesting model that we think has got some potential. And actually, the author of the article, Jeff Cornwall, is a professor at Belmont University here in Nashville, which has one of the most highly rated entrepreneurship programs in the country. And we work regularly with his folks. But yeah, we're very familiar with InCrowd and what they're doing, and are very interested to see how it develops.
That's awesome. It looks like Phil Schmerling's doing a pretty cool blog here called the Crowdfunding Capital blog that is aggregating a bunch of resources and information on the topic too. So if you're looking for more information there, that looks like a good place to go. The other thing that the good doctor mentioned in his piece, Dr. Cornwall, is something called Seed. Seeds. What an interesting model this is. The marriage of Farmville and Kiva, as they describe it. It's a game site, but as you pour money into it, to speed up the processes of the game or whatever, you're actually funding companies with that money. So that seems like a really cool model. Are you guys familiar with this?
I hadn't seen that one before I read Jeff's article, but I agree. It's, you're seeing a lot of a trend towards introducing gamification concepts in a lot of different businesses, and this looks like an interesting twist on doing that in the funding context.
But I'm wondering if you're just, pouring the money in and you're not actually getting anything out except for your gameplay at this point. I suppose I would feel better about my son's time spent in Dragonvale if I knew there was some kind of public economic good coming from it other than simply fattening the coffers of Dragonvale.
Oh, so, it's all metaphysical because you're getting karma points too because you're contributing. So there's a great big, account in the sky that you're filling as well. You can feel good about it.
Yeah, I suppose so. All right. Well, let's move on and take a look at what's going on at the intersection of technology and entertainment. I wanted to check in with the AutoHop feature and the case that's going on about it. Dish Network apparently is sticking to its guns and not backing down about its commercial skipper. I'm reading that I actually was unfamiliar with the fact that Dish Network is now Blockbuster or bought Blockbuster or otherwise, has inherited the assets of Blockbuster. So to the extent there are still Blockbuster stores around, you can go into some of them and test out how the AutoHop will work. According to Dish, this is just the latest innovation in DVRs. Of course, people don't want to watch commercials. That's a good deal of why people have DVRs in the first place. It's not just about time shifting. It's about what you can do once you've time shifted the thing, which is get the commercials out of there. But of course, the plaintiffs in the lawsuit don't feel that way at all. They feel that there's somehow copyright infringement going on here. And so the whole thing continues to move forward. The LA Times had an interesting note in their coverage. Let's see. This is in their company town column. That it's only the major networks that are actually available for the AutoHop service. So the cable channels don't actually benefit from that. The TNT, Spike, FX, those kinds of channels. The feature's not available there, and the author of this piece in the LA Times, Joe Flint, seems to be speculating that this is all leverage by Dish, that they want to be able to have more advantageous rebroadcast, retransmission fees with the big networks, and that this is their game piece for making that happen. I don't know, how much credence there is to that, but it's an interesting thing to note. Public Knowledge, it looks like, has thrown in with AutoHop and has filed an amicus brief trying to prevent an injunction against the company. Evan, any thoughts on what's going on here?
Well, first, every time you say AutoHop, I'm thinking that you're copping a Boston accent and you're talking about that musical instrument that is so popular in bluegrass music, auto harp. But yeah, Public Knowledge's brief, I think, is pretty good here. And what it really does is reveal the fact that this is not a copyright dispute. This is a dispute over revenue and there. And for those of you watching on video, there was a picture of an AutoHop. Somebody, some gal from Tennessee playing an AutoHop.
Good old Boston Bluegrass, one of my favorite genres.
There you go. So this is not a dispute over copyright. Copyright is a front for the real issue here of preserving the revenue model of the legacy system or the incumbent, the plaintiffs in this lawsuit here, because, it's doesn't take too much extrapolation to figure out that the fewer people who are watching ads, commercials on TV, the less ad revenue there's going to be. Advertisers don't want to pay to, run ads that nobody's going to see here. And so I think Public Knowledge College's amicus brief really nails the legal issues in all this. I mean, first of all, pointing out the implausibility of Dish actually being a direct infringer, citing the cases like Netcom, pointing out how there's no volitional act on the Dish Network's part to implicate any copyright rights. And then, for that reason alone, there's no secondary infringement going on. Well, no, I guess that's not the reason there's no secondary infringement going on. The users are not infringers either, so therefore Dish cannot be a secondary infringer. And it's really interesting to look at the argument that it's making for why the users are not direct infringers of copyright. For one, just skipping over a commercial doesn't implicate any of the rights of the Copyright Act that are in Section 106. You're
right.
not making a copy, you're not displaying it, you're not making a derivative work. You're just skipping ads. And all these great arguments are, in the brief before you get to the real grand slam in all this, which is the time shifting fair use argument from Sony, the Sony case from 1984, which says that the VCR is okay because it's just users use it to time shift, and that's a fair use, and so there is no infringement here. So not only are the users not committing infringement by taping, episodes of the Cosby Show or whatever else was popular in 1984, but also the manufacturers and the distributors of the VCR are not secondary infringers, just like AutoHop. Dish Network should not be in this one. So it's interesting to look at the underlying issues that are really driving this revenue and whatever else. And Dish's interests would be in providing a great product that its consumers want, and the consumers' interests are in having the ability to watch a show in a shorter period of time, skipping over the ads. So different interests going in different directions here. They're not all copyright interests, but it's kind of crystallized in that context, and that's how it's talked about and how it's actually brought to court.
I would think.
I'm thinking, Chris, go ahead.
Yeah, I haven't read the complaint, but I would imagine the argument goes that the entire broadcast is a copyright consisting of a collective work or a compilation of works, the show plus the programs, and that's why they're probably arguing that it's an unauthorized derivative work. But I think it's interesting to note that this battle was fought once before. In the early 2000s, when TiVo first came online, it had a competitor called Replay TV. And Replay TV had this commercial skipping function built into the box. I actually had one. And it worked really well. And you would play a show, and it would essentially automatically skip through the commercials. And it worked about 95% of the time pretty well. But the networks got together and sued Replay TV right into bankruptcy, and they went away. And I was sort of expecting that it was going to come up again at some point, and I guess here we are.
Right. Well, as a lawyer for entrepreneurs, I building a better mousetrap is what your clients are frequently all about. So how do you feel about the entertainment industry's attempt to squelch that in this case?
Well, I have mixed feelings about it. I think Evan's absolutely right. What's really at issue is revenue. And I think the problem is that they're still a little bit stuck in a revenue model that's based on subscriber fees, which in turn are calculated based on advertising dollars. And so that's what they're trying to protect. And I don't know the answer to that problem. It's probably going to require some sort of an evolution of the revenue model, just like the music industry had to go through when Apple launched the iPod and iTunes. So I'm sympathetic to the problem, but at the same time, I'm always opposed to anything that stifles innovation. And I think in this case, the commercial skipping function is something that there's obviously a high demand for. I know we loved it when we had it before, and we missed it when it went away. And I think that this is in some ways analogous to the music industry suing their customers. That they just don't really know how to deal with it any other way.
Yeah. Will, let's assume that the music industry does not prevail here. How do you think they're going to respond to DVRs that have this kind of feature, or to DVRs in general? I mean, I think my take on it is they're just not big fans of anything that permits you to skip commercials, which of course you can do without AutoHop. Do you think we're moving toward a world where everything's going to be on demand and with commercials that you're not able to skip, a la Hulu?
Yeah, I mean, I think that I think that the networks have known for a while that their revenue model doesn't really make a whole lot of sense moving into, the cable companies have really beaten them out in a lot of ways. And so they're really scrambling to find anything they can to survive. I think what Dish is doing here is they realize the power and the leverage they have over the networks. And although I'm not sure this strategy, I think whereas I usually like to support the technology companies over the incumbents, I'm not really sure the technology here is all that innovative. I think it's really Dish trying to, protect its revenue models, and I'm not sure the technology is really the driving factor. At the same time, I think that it will have the effect of trying to push the networks to try to come up with their own technology that will, effectively prevent users from skipping commercials. And so hopefully the net result is it pushes the networks to try and create their innovation of their own. And that, if it comes to pass, I think would be a net positive for consumers. And we can all thank Dish Network for that. But, it's not always the case that these incumbents see technology as the way out. Sometimes they see litigation as the way out. And we saw how that worked with the music industry.
Well, I'm kind of wondering, and before I go on to this next story, let's make auto hop with or without a Boston accent our second MCLE passphrase for the show. I'm wondering when the entertainment industry companies are going to start going after big advertisers like Ford and Coke and various big advertisers online that are showing up as the ads featured on, very clearly infringement-oriented download sites. This is something that goes back to a blog post by somebody called the Tricordist, found Mini Cooper and Ford advertising on such a site. Also Target, State Farm, Adobe, Alaska Air, AT&T, the Boy Scouts, DirecTV, LG, Princess Cruises, HP, Westin, Charmin, and Rapid Share.
Oh, let's just boycott them all. Let's just, grow our own food and, live out in the wilderness somewhere.
Well, I mean, the underlying problem here is that, the advertising function gets outsourced to an ad network, and then the companies just kind of wash their hands of whether or not that network pays attention to what sites the ads are placed on. And the end result is you've got the Mini Cooper ad next to here, download this Neil Young song for free, and not using iTunes or anything else that takes money to the artists or the industry. So is there liability here, do you think, that could possibly attach? Do advertisers have to be more conscious of where their ads are popping up? What do you think, Evan?
Well, first of all, I'm trying to figure out if there was any plausibility in saying that somebody who was interested in a Mini Cooper would not listen to Neil Young and vice versa. But so I don't think that's the way to solve the problem. But I don't think this is a problem with the ad networks themselves. I mean, they're just out there to put ads. It's, ad networks are very broad, going to an innumerable number of different sites. I just realized that's the second time I've used the word innumerable in the same episode, and I try not to use words like that twice in one episode. So, it's not an issue with the ad networks. The real issue here, if there is one with it, is with the piracy that's going on, the unauthorized downloading. I think it's too much to ask the ad networks to worry about these types of things, because they've got to be in the business of reaching the biggest number of people who can potentially see this stuff. It's too much of an onus to put on them. And I think also, on top of all this, it would be way too tenuous to say that there is any connection between the revenue that the ad networks may be generating, either for themselves or for their customers, clients, between that and the infringing activity. These are not intentional things. And so I just, it's one of those things that, should be handled as well as it can, but not something that should be, we certainly don't need to be pointing the fingers at the ad networks in all of this.
Will, do you tell clients to pay attention to where their ads are going to be popping up and how their ad networks operate?
I can't think of any clients that have run into this issue, but I would say it's definitely something that's really attenuated for a company that is just like you were describing. They put their dollars into an ad network. They put their advertisements into an ad network, and they really have very little control after that point. And the sort of downstream process would be really difficult to control. This all comes down to an issue of who's in the best position to kind of prevent these things from occurring. But it also comes to a point, some of the sites that were mentioned in the article, such as RapidShare, they've been sued for copyright infringement in the past and have been acquitted in some cases. So even though there is infringement that goes on in that site, where do we draw the line to say this is a site that you can't be advertising on and these are sites that you can? Does it mean they have to be convicted in court of copyright infringement, of secondary infringement, of something of the like? There's a whole standard behind that outside of the sort of court of public opinion, how we draw these lines would be really, really difficult for the companies themselves to handle.
Well, this is all kind of raising an echo of something for me back in the many, many pieces of litigation brought by Perfect 10 involving Google, where I think at one point they asserted that, Google ads are appearing on these kinds of sites where, our product can be found in an infringing way. And they were trying to attach further liability to Google because of that. So I don't think it's the first time this kind of argument has been raised. I wouldn't be surprised to see it again, but I'm not sure I can think of any case where someone has prevailed on that. Chris, is this ringing a bell for you too?
Yeah, I mean, it's a tough issue, but I'm inclined to think that as Will said, there's not enough of a connection between where the ads are being placed and the content on the sites for there to really be a practical legal issue for the clients.
Okay, well, let's move on. Evan, you remember a few weeks ago we talked about the Christian Louboutin case that they prevailed on having a distinctive trademark in the red bottom sole of their shoe and the contrasting top part in their case against Yves Saint Laurent. And I thought it was kind of interesting just from a trademark and fashion perspective. But over at Forbes, there's a really good piece on how this determination could have broader implications for those doing business on the web. John Villasenor has written up a piece about what this means for trademarking colors on a website. And, you can, in the world where the CNN page is very distinctive, the Facebook page is very distinctive, and everybody tries to make their website and its colors, I would say. Just looking at the Forbes page with its big sort of charcoal gray bar at the top, trying to definitely use color in their brand identification. It seems like we're kind of perhaps on a slippery slope to where, here over on the TWiT site, we have this sort of aqua blue that permeates everything. It seems like we're on kind of a slippery slope with these cases of saying, okay, that's my color. And you'll recall that Facebook had a number of cases, a flurry of them, a couple years back against various sites that were using Facebook content. Lamebook in particular, they settled with. It's still there, but it has a big banner at the top now saying we are not affiliated with Facebook in any way. But again, they've borrowed the typeface and the colors. And it seems to me like under this decision, I agree with John Villasenor here that we could start to see more litigation about this, and it could affect how startup companies are establishing their presence on the web. What do you think about this, Chris?
Well, I think slippery slope is a good way to describe it. There is a long history of companies being able to establish trademark protection around colors, like UPS and the color brown, for example. And then you've got a whole body of law around trade dress, which is more than just the color, but that could govern the entire sort of look and feel of a business. I don't really know how this is going to play out long term in terms of these websites, but I think what you'll likely see is the courts are going to take a fairly cautious approach to the notion that a particular color could be associated with a particular website as a trademark unless there's really substantial and lengthy evidence that consumers really associate that color with that particular brand. I think you might see more trade dress around the overall look and feel, which I think was a lot of what was at issue in the Facebook and Lamebook case. But colors by themselves, I think it's going to be a tough road for a plaintiff to go down.
The Forbes piece uses CNN as an example and poses the question whether that distinctive red color can establish trademark rights, and says the answer turns, among other things, on whether the stripe's color and placement are distinctive. Most likely, yes. Whether its use by competitors would create customer confusion, quite possibly, and whether it steers clear of being functional, maybe. So it seems like we're a good way there. Evan, any thoughts on this?
Yeah, I mean, I don't think that yes, there could be a slippery slope here, but I agree with Chris saying that courts are going to be cautious about all this stuff, and the tools by which the courts can be cautious are already very firmly established in the law. I don't think we need to revisit what the Trademark Act says or what the regulations say or what trademark examiners are supposed to consider when they're looking at applications, in the trademark manual of examining procedure and all that stuff. Because, dividing the universe quickly into half here when it comes to color and trademarks, color can be claimed as an element of a mark. Facebook has a blue background, and that can be considered in the infringement analysis if somebody else like Lamebook were going to start a service that is likely to cause confusion with Facebook. That's a separate question and a different question in nature than to whether the color itself can be claimed as a trademark. And that is available in a very limited set of circumstances because, for one thing, in order for a mark or for color to serve as a mark, it has to have acquired distinctiveness. And that means over time the consuming public has come to associate that color with that brand. Pink for Owens Corning fiberglass insulation, brown for UPS, like what Chris was talking about. And so for there to be acquired distinctiveness, the use of that color has to be in a non-functional sense, and it has to be continuous, for a long period of time. The Trademark Act talks about 5 years at least, and it has to be exclusive. And I think that's the real going to be the big tripwire for courts to realize that they don't have to find that colors are entitled to trademark protection in a lot of situations, because I'm sure we could go out there and find a whole slew of other news sites who are using red and even red banners at the top to distinguish their information services, their news information services. So in situations like the CNN webpage, I would not be very persuaded at all to think that is should be entitled to protection as a trademark, the color itself, because of this lack of exclusivity. Yeah, it has become associated with CNN, and it may be continuous for a long period of time, but it's certainly not all that unique if we were to look at all of the online news service providers out there. And I think that would be a phenomenon you would see with a lot of web-based enterprises. It's a different world than the world in which Pink was given protection for fiberglass, and the internet is different market than the fiberglass insulation industry. So I'm not too worried about falling down that slippery slope anytime soon.
Okay, well, that was a really good description of why red websites are different than red bottom shoes. I appreciate that. Evan, I think that you put this in our rundown. It's sort of the Gattaca story here, the societal risk of trying to create a pedigree super race.
Right.
Let's talk about this. Body hacking and equal access to genetic enhancements, I guess, would be the way to sum it up. Where are we going with this?
Well, you and I love talking about the singularity and, the advancement of technology and the accelerating pace in all areas of information technology. And particularly, we enjoy talking about cognitive enhancement, augmented reality, and things like this. And so what's even more fun than talking about the technological layer of the advancements we're seeing that are taking us to the singularity is the discussion of the legal issues that could be occasioned by these advancements. And so this article about the characterizing it in terms of the societal risks of trying to create a pedigree super race are interesting. Because they bring to the forefront some social justice questions that cause us to think about fundamental issues like equality and what, some natural rights that people have. And I guess you could even bring in some flavor of the healthcare debate and the norms that underlie, universal access to healthcare, Obamacare or Romney care, however you want to characterize it, the changes in the shift in norms that we've seen in the last 10 years, at least as expressed by Congress's things. So, some particular questions, that might arise from this is, say we're at a state someday where, it's technologically a non-issue to enhance someone's cognitive function, to make them smarter, just by implanting a small microchip underneath the scalp, or injecting their bloodstream with millions of little nanobots that enhance the neurological features so much so to an extent that it becomes the norm for people to augment themselves so that they're more intelligent, and they thereby have an advantage over the person who chooses not to do this. You might even say that it is they take on traits that may make them evolutionarily superior, more traits that would be selected for in the evolutionary process. So what's the role then of healthcare and funding for healthcare, and should it be part of your employer given benefits that you should be entitled to have these adjustments made to yourself, not have to pay for them yourself. So these shifting advances, or these advances in technology, may cause a shift in norms, which you can look at it from one way. What are the rights of the people who want to take these enhancements on? But then perhaps even the more intriguing issue is, how do you handle the rights of those who choose not to augment themselves, but instead want to, live naturally and not have bionic eyes and organs and limbs and everything? How do we preserve their rights when the norm may shift toward a more advanced human state? Listen, I don't have good answers to these questions, but this is a great way, a great context for considering how we're going to really handle on a macro scale big shifts of how we think about justice and equality and liberty and due process and all these things occasioned by wondrously advancing technologies that open up worlds that we can't even imagine at this point.
Well, maybe this will be written into a future draft of the Jobs Act that only genetically selected, accredited investors need apply. What do you think, Chris?
I think so. It's interesting. This is sort of a mind-blowing topic to think about, because there's so many different ways it could go in the future, and I feel like you need an ethicist on the show instead of a lawyer to comment on it.
and I think there are also some issues similar to what Evan was bringing up, but if you think about parental rights issue, what if all the kids have these genetic enhancements, but one parent says, I want my kid to be natural? Are they harming their child at that point? Are they keeping their child behind? What are their rights as a parent to choose whether or not to use genetic modifications? There are all sorts of angles to this issue that are really interesting, I think.
That's right. And it's sort of shades of the abortion debate too. Does your fetus have rights to decide what sort of enhancements he or she will or will not enjoy? Very interesting stuff, Evan. Thank you for bringing that to our attention. Our resource of the week is straight out of the Baker Donaldson Emerging Technology Practice. It's actually, we're calling it our resource of the week, but it's a series of tips of the week. It's a video blog called the Entrepreneur Minute that covers, I think in just maybe it's a minute long, but in little snippets, some great practical advice for entrepreneurs and startup companies. Things like what body language can tell your potential investors, ensuring your non-compete agreements are unenforceable, when you should get into a partnership and when you shouldn't. All kinds of great practical advice here. Chris, you want to tell us a bit more about the Entrepreneur Minute?
Sure. I think you did a really good job of summarizing it. It's really just an attempt on our part to provide content for our entrepreneur communities that is in a format that's easily consumable in the day and age of everyone having a smartphone or an iPad, where it's a lot easier to look at a 60-second video tip than maybe to read an article on your phone. And so what we did was we have worked not only with our own attorneys around the firm, but we've brought in investors, we've brought in entrepreneurs, we've brought in interested experts from all around our communities and filmed a number of these segments, and we put one out every week, and we'd certainly welcome both more subscribers. It's free, and it just comes in as an email link. And then if you have suggestions on topics or even would be interested in participating at some point, by all means drop us a line and we'll take that into account.
Have you had Phil Schmerling on yet?
Not yet,
the in-crowd guy?
Not yet, but when we do our film our set of them here in Nashville, I think he's going to be on the list.
Good. He seems like he'd be a good candidate. All right. Our tip of the week is sort of tongue-in-cheek. I know that no lawyers who listen to this netcast would ever do what happened in this case. But in Miami, Florida, things just seem to happen in Florida. That's why Carl Hiaasen writes such great books about the place. A public defender was representing a murder suspect whose family brought the guy a bunch of clean clothes to change into and wear to trial, including a pair of men's underwear in leopard print. And the lawyer, a female public defender named Anya Citron-Stern, decided that the underwear were comical enough that she snapped a photo with her cell phone, put it up on Facebook, of course, just to her friends, with some snarky comments about how my client's family thinks this is appropriate trial attire. The defendant had been trying to get rid of his legal team for a while, and when this came out, the judge finally granted the defendant's request. There was not only did his lawyers get discharged, not only did Anya Citron-Stern get discharged from her job, but there was also a mistrial in the case. So whatever they had managed to accomplish in the courtroom got reset, and there was a do-over here. So if you are a lawyer and you think that something your client does or wears is funny, don't put it on Facebook. It's a bad idea. Evan, any thoughts about this?
I don't see what the big deal was. I think it was just fine. No, I mean, I had a conversation yesterday with one of my colleagues. You know, did she get her First Amendment rights violated by getting fired, you know, for doing this? And I think the answer is probably not, because she was the public defender, and I think that's publicly funded in most things. So she was like a government employee, right? So why should she not have the right to do this? And didn't the government, you know, infringe on her rights? And probably not enough of an issue of public concern, which makes it kind of a comical analysis, you know.
The right to view leopard briefs.
Well, I mean, and the best argument I could make, if I had to on this, was like, you know, she was taking this in connection with them doing a search of her client's bag for like safety reasons. So the public concern could have been, oh, look how thorough the security guards are in evaluating what's in this bag. So you should feel safe that they're only uncovering items like this rather than knives and guns and things like that. So there, you know, in law school, you can learn how to make tenuous arguments. So I'm demonstrating that skill that I have for you right there.
Well played, Evan. Well played.
Rock solid. Yeah.
From my perspective, she broke what I call the law of common sense. She just really didn't think too clearly about what she was doing.
Now that's no fun. That's no fun. She was just fine. I think we should do more of this.
Client underwear flown like a flag across every social network that you participate in. Yeah. It would certainly make the world a more entertaining place. I was quite entertained, unfortunately, at this poor lawyer's expense and at the judicial system's expense because they have to redo the trial. But the whole thing just kind of tickled my funny bone. Not to malign our friends in the great state of Florida, but you guys do get some funny stories down there. All right. Well, this has been an episode of This Week in Law, and we've been really thrilled and honored and grateful to have the company of Will Norton with us this week. Thanks so much, Will.
Thank you, Denise. It's been a pleasure.
Will, are you on Twitter? I was looking for you there. Couldn't find you. Can we plug your Twitter handle?
At Norton Will, NortonWill.
There we go. So that's where you could find Will on that particular social network, hopefully not flying any client undergarments. And of course, also at the Baker Donaldson firm, along with Chris Sloan, the co-chair, right, to the emerging technology practice there.
Indeed, and thanks for having us on. And I will say that in my practice, I hope to never see my clients' underwear, and if I do, I will be very concerned.
Yes, there is really no time or place for client underwear in what we do, but it seems to come up from time to time. C.A. Sloan on Twitter. Anything else you want to plug, Chris, before we go ahead and let you go?
No, we appreciate you letting us come on the show. I mean, as I mentioned earlier, we have an emerging companies practice around the southeastern U.S. where we are trying to be the go-to law firm for startups in our footprint. So if you're starting a company and you're in the southeastern U.S., feel free to drop us a line, and we'd love to talk to you about how we might be able to help.
All right. Thanks so much. Evan, it's been great chatting with you again.
Lots of fun. Yeah, some good topics on this show. And then, when we can start with topless photos of Kate Middleton and end with client underwear, I think that's a good episode.
It's sort of, sandwiched everything in.
Yeah,
yes.
There we go.
And innumerable good stories in between.
Yes,
so.
Yes. Say it again.
Yes, say it again. Say it loud, say it proud. All right. So you can find our innumerable past episodes of This Week in Law at twit.tv/TWiL. Also over on YouTube, in iTunes, however you like to consume this kind of entertainment/educational content, you can find it where you'd like. We try and make our stuff as easy to get to as possible, and make you have all the options you can to have it available on your iPad, your iPhone, your computer, your TV. Roku boxes are great for that. We have a Facebook page and a Google Plus page for sort of sandboxing things between our shows. We'll put up our topics in progress and ask you what else is on your mind. We love hearing from you there. In fact, the whole Mitt Romney twist to our privacy discussion came from a contributor on our Google Plus page. So definitely chime in about these things because we love to hear from you. You always give us good ideas. What else, Evan? Anything else?
No, I can't think of a thing. There's nothing left in my brain.
Nothing left in your brain. Evan, of course, writes a great blog over at internetcases.com where he covers this kind of material on an ongoing basis, and he's at Internet Cases on Twitter. I'm D. Howell over there. And you can reach both of us if you're more shy than a Facebook page or a Google Plus page permits, then email us. He's Evan at twit.tv. I'm Denise at twit.tv. We love to hear from you, however you send us feedback and suggestions. And next week, we've got a really fun show coming up. The book Free Ride, written by Robert Levine. If you haven't read it, you might want to grab it before next week's show because we're going to have him on kind of a controversial indictment of technology as the great destroyer of the creativity and culture in our society today. And we're also going to have Latif Matima back on the show, a Howard Law professor who has had some comments about that book himself. So look forward to that next week. And until then, we will see you around the interwebs. Be good out there.